Good afternoon again, ladies and gentlemen. It's now 5 minutes to 11. And pursuant to the Texas Open Meetings Act, this is a special called meeting of the Commissioners Court of Hood County, Texas. Today is Tuesday, April the 26th, 2022. It is actually about 3 minutes to 11 a.m. It's immediately following the Commissioners Court. We're in the Ralph H. Walton Jr. Justice Center, the Century Jury Room, 1200 West Pearl Street, Granbury, Texas. The item that's on this, and the only item that's on this, is to discuss, consider, and take action to enter into a general service agreement with Bickerstaff, Heath, Delgado, Acosta, LLP. And we have with us today Mr. Chuck Killow from the Bickerstaff Law Firm. Two people want to speak on it. Okay. More. Three. I've got total of 5. We'll go ahead and let him speak first. Yeah. I'm gonna come on up, Mr. Kimbrough. Got a little thing going on here today. Okay, so I'm gonna let you tell us about this, what we can do, what you were hired to do, and what this contract comprises, please.
May it please the court.
Yes, sir.
County staff, ladies and gentlemen. My name is Chuck Kimbrough, Charles R. Kimbrough. I'm a partner with Bickerstaff Heath in Austin. And the agenda item talks about a proposed engagement position, legal services engagement position called a general service agreement. I was contacted last week and requested to offer a proposal to the Commissioners Court for consideration. And on April the 21st, after we did our internal work, client acceptance, conflicts check, things like that, I authored a letter dated at 21st of April to the county judge with a copy of the proposed engagement documents attached. It is my understanding that the court has a copy of the letter and the attachments. Is that correct?
Yes.
Now, I want to tell you why I'm here. Our law firm began in 1980 when Mr. Steve Bickerstaff and Mr. Bob Heath came out of John Hill's Attorney General's office and formed the law firm. And from that point forward, county government and other local government work has been just about all that we do. And since inception, we're a full-service law firm for Texas counties. You've probably seen me or lawyers like me from our firm give talks at the conferences, the Conference of Urban Counties, Texas Association of Counties, the VG Institute of County Government, the Regional Association, meetings of the County Judges and Commissioners Association, things like that. But we're a statewide law firm in terms of the reach of our clients for local governments. We represent not only counties, but cities and school districts, colleges and universities, special districts like river authorities. For instance, the Brazos River Authority has been our longtime client. So local government is primarily what we do. That's like saying the Pacific Ocean is a pretty big pond. Well, local government's a big pond too. But we have practice experience, particularly from inception of our law firm, full service to counties. And public official qualifications as employment matters, as ethical matters, is something that we have from time to time for counties been asked to help on. But the real reason that I'm here is because of Hood County. Y'all may not know it, but from time to time through the past 30 or 40 years, you've been our client. So when I received the call from the county judge, I took it, because we always want to try to help a former client if we can. I don't know that we can in this instance, but after visiting with him briefly, very briefly, about this matter that's come up that y'all have been discussing today, I said, well, maybe the proper thing to do is to offer what we call a general services agreement that contains a lot of stuff at a no money up front. You don't pay anything unless you actually ask us to do the work. No minimum fees or billing, no monthly retainer, no retainer, none of that. Just get hired for a broad scope of matters as the agreement says, and we can go through it. But with the idea is, if we hear from you to do some work, then okay, but you don't have to call us at all. It's non-exclusive. But if you think that our skill set and our competence and experience in the matter that you have means that we should be the ones doing the work, it means you've already hired us, and you just pick up the phone and contact us, and we do it. And then you get charged. So it doesn't cost you anything at the front to do one of these general services agreements, okay? Now, we want to try to help you if we can. I need to define who the you is. Our client will be the Commissioner's Court. It will be Hood County, but it'll be the governing body of Hood County, which is the Commissioner's Court. And that raises governance issues, doesn't it? A Commissioner's Court is different in Texas. County government is different. A county cannot do anything. Commissioner's Court can't regulate or decide or engage in anything unless the law of the state of Texas expressly says you can or implies that you can. Now, that's a rule that you learned soon after you took your first oath as a member of a Commissioner's Court, isn't it? It's my understanding, at least a couple of you are lawyers, but some of the best lawyers I know are some county commissioner friends of mine that never went to law school. So the Commissioner's Court, as some people have discussed a little bit today, is a limited regulatory and administrative body. You can't do anything unless the law of the state of Texas says you can. Way different than a home rule city, for instance. I believe Granbury is a home rule city, isn't it? Home rule city has the full power of self-government. And you look to restrict the home rule city's powers by looking at where in the law it says a city cannot do that. County government's 180 degrees different. You can only do what the law of the state of Texas says you can do. And what's the next governance issue? You have to act as a body. The word or the signature of one member of the Commissioner's Court, even if it's the county judge, means nothing without a recorded vote in a public meeting pursuant to the Texas Open Meetings Act recorded in the official minutes of the court. So, it looks like the court is considering hiring our law firm not to conduct a substantive investigation into alleged facts, not to do that, but to represent the court as the governing body and give you advice about what your legal authority is or is not to answer the request of the petition. Does that sound about right? Not to take sides for or against on the merits, but strictly to give limited professional advice to the court about your lawful authority to do or not do what the petition asks you to do.
So for clarification there, you're saying that your firm is not looking to do an investigation into the accusations and the facts of this case. You're just looking to guide us in what is legal.
I'm not looking for anything. I heard that y'all were looking.
Right.
Okay?
So
I'm not looking for anything.
okay, you're offering to.
I am suggesting that based on my conversation with Judge Massagill, he did not say, come down, we want to hire you to conduct an investigation. That's not what was going on. He was concerned about, now he's been a lawyer for a long time, but not exactly this stuff. Right? He was concerned about the right of the people to file their grievances with the government, like you do see from time to time. You get petitions or statements or, signed pieces of paper by residents and voters about do this or do that. He was concerned about the proper response, the respectful response to the people that signed the paper and gave it to you. He was also concerned about the lawful authority, the correct, proper, lawful authority for the Commissioner's Court to do anything that they ask. He wanted to find out whether we could, if engaged by a recorded vote of the court, help the Commissioner's Court, help the governing body define your role, not to do a substantive merits investigation. Okay? That's as plain as I can say it, gentlemen. That is not what I was asked to come here to talk about or to do. Is that correct, Judge? That is correct. It was more of a rules of the road check ride. Now, I will tell you, if you've ever heard me speak at the county conferences, that 2 minutes of governance issue stuff that I just mentioned to you, limited regulatory body, you have to have the express or implied power of the Texas statutes behind you to do it. If you don't, you're outside the scope of authority. That is the crux of the matter that the judge thought the county would need to hear from an outside lawyer. Now, maybe that's not true. Maybe the court in its wisdom decides, good to see you again, Kimbrough, come back anytime, but we're going to pass today. If that is the case, that's okay. Like I said, that's not the reason I'm here. The reason I'm here is because you've been our client off and on for a long time, and I wanted to show you the proper respect to show up. Do you or the members of the gallery have any questions for me? Mr. Eagle.
Yes, sir, I do.
Yes, sir.
And I want to make sure this is clear. You were contacted last week by the county judge.
Yes, sir.
And you've told us that the client is the Commissioner's Court, correct? Your client, if the Commissioner's Court hires your firm, your client is the Commissioner's Court, is that correct?
It says it, yes, sir.
And you understand that the judge made a decision to contact you on his own without bringing this to the Commissioner's Court first. You understand that?
I didn't know about that. All I know is that I got the call.
But And you've quoted us a hourly fee for legal services as well as an hourly fee for paralegal services, correct?
That's true.
You've quoted $340 an hour for legal services, correct?
For
Legal, for law, for
attorneys.
lawyer.
Attorneys,
lawyer.
yes, sir.
I'm sorry. And you've quoted $180 an hour for your paralegal services, correct? That's in your contract.
I want to make sure. I can't remember. 180, yes, sir. Plus the recovery of reimbursable expenses.
So who do you envision as the person who is going to be your point of contact? Any and all commissioners and the judge? Do we all have a, since the Commissioners Court arguably is going to be your client, you've told us that, who, does that put it in a position where each commissioner and the judge has the ability to contact you and discuss issues with you?
Actually, that's up to the governing body, and the governing body can also agree to let the county attorney or the DA or the auditor.
So we can agree to do that.
Yes, sir, it's your prerogative.
But you presented us an order where it states that the county judge can do that.
No, sir. The order, all of you sign, but somebody has to sign the contract. Okay,
so right now your proposed order is just to sign the contract, correct? That you're proposing that we present and vote on.
The engagement agreement is attached as Exhibit 1 to the vote order. Do you have that, Commissioner Eagle?
Yes, sir.
Okay.
So, I don't want to, there's no sense getting into the weeds onto that right now. But the whole issue here is that the judge took it upon himself, sua sponte, to reach out to your firm because of a petition, an alleged petition that was presented to this court a couple of weeks ago. Is that your understanding?
You said alleged petition.
Well, a petition, okay.
There's some papers that constitute what's called a petition that he said were filed, and that was the matter that he felt like they needed to help on.
Okay. So in other words, any set of citizens out here who desired to bring a petition similar to the one that was brought in here 2 weeks ago can bring up their petition in here, and your firm could be used to advise on such petition, correct?
Only if you choose to have us work on that extra petition.
As a county commissioner on the Commissioners Court, if your firm is retained, am I one of your clients as a commissioner?
You're one of my client representatives, Commissioner Eagle. Yes, sir.
Do we have speakers? Yes. I have more to ask, but I would say I would prefer to, I don't have any more really. Thank you for your being candid with us, and I appreciate you coming. I know you're in a difficult situation, so thank you. But I don't have any more questions at this moment. I reserve my questions for later.
Thank you for your kindness.
Actually, I have one more comment. Did you have any authority for any of the rest of us to talk to the tax lawyer, Jim Allison? Did you call and get a meeting authority from all of us? Research. No, you didn't. That's research. We do that routinely, do we not?
Judge, if you got together and talked to us about this, you'd be in violation of the Open Meeting Act.
That's exactly right.
Isn't that true?
That's right.
So you can't talk to us and find out whether you should do that until you come to court.
That's right. I just contacted Biggerstaff Law Firm because I know their reputation, and I want to make sure that everybody's rights are legally protected. That's it. Now, we get up to the first speaker here. What, you want to have a seat right here while they do that, and then we'll call you later, or if they have a question.
I'll just retain my seat in the gallery if that'll be okay.
That's the deal. Thank you, Mr. Hewitt. All right, David Fisher.
Let me start by asking whether I should be on a timer, because I am a publicly elected official. No what?
You're allowed to take as much time as you want.
Okay. I won't take the 3 minutes. First of all, whenever we're talking about the matter of residency, you're talking about, first of all, elections, in which case that's not the purview of this court. That's the purview of the parties, whether Republican or Democrat, in this case Republican. So I'd like to ask, first of all, why are you stepping on our toes? It's really my job, not yours. I understand wanting to be legal and right, and I applaud the attorney for specifying that he's not going to do an investigation. He's going to do just advise on matters of law, and I appreciate that very much. And I appreciate wanting to stay within the law. If that's all you're going to do, then I have no objection. If you're going to start investigating elected officials, that's horrifying. The idea that this court could go after an elected official, just the thought of where that would lead is beyond comprehension. That's why we have courts. That's not, this is called a court, but that's not what this kind of court is. Let me read the law again. It says, and I'm reading from Texas Local Government Code, number 87, paragraph 15. Any resident of this state who has lived for at least 6 months in the county in which the petition is to be filed and who is not currently under indictment in the county may file the petition. So it doesn't even have to be somebody in this case, District 4. It could be anybody in the county. Anybody that's been here for 6 months. Any of you as individual citizens could file this petition. And if you want to do that, please go ahead. That's the appropriate response. But this petition that was submitted 2 weeks ago is inappropriate. It went to the wrong place. There are appropriate places for it to go, either the Republican Party or the district judge. Either one is fine. If you want to go there, let's do that. Let's hash this out. But this needs to stay away from this court. You guys need to run from this as far as you can. I think I'll stop right there. Thank you.
Okay, then that's
Yes? Okay.
and that's that.
Good morning. Thank you for the time to speak. First, as stated earlier, you have already heard from Ken Paxton, the Attorney General. You've already heard from your TAC attorney, Jim Allison. You've heard from the chair of the Republican Party that this issue does not belong in Commissioner's Court. It belongs as a proceeding in the district court. However, 3 of you have decided to ignore that legal advice, which, assuming that's what you're now asking for is legal advice, which you've already gotten from the Attorney General of the state of Texas, and you've already gotten from your TAC attorney, Jim Allison. But you've chosen to ignore that advice, so I went ahead and reviewed the contract, as you know I always do, and I do have several questions. And again, if all you're seeking is just a clarification of the process, which is in the election code, we have a county attorney, Matt Mills, that could answer that question for you. Or a district attorney, Ryan Sinclair, who both are qualified to answer those questions. So since you have decided to ignore all the advice that you've already been given, I want to let you know, after reviewing the contract in detail, that this contract puts the county budget at risk, and as a taxpayer, that is unacceptable. You are signing Hood County taxpayers up for an unlimited expense for an unlimited time with an undefined scope. And as Mr., I'm probably not going to pronounce your name correctly, Bickerstaff? The Bickerstaff Law Firm, Mr. Kimbrough had said, any of you can just pick up the phone and give them a call and you'll be billed later. This is a time and materials contract. There are no limits by time frame, spend, number, frequency of requests. There are no controls. Wow, that was quick to run out of time. One thing I want to point out is that this contract excludes election law. If you look at the Exhibit 1, it says that it specifically excludes election law. You might have missed that. So I had a lot more to say, but I'm running out of time. So lastly, you are signing Hood County taxpayers up for an unlimited expense for an unlimited time for an undefined scope. This is outrageous at this time when there's already pressure on the budget from inflation and salary adjustments that you have recently voted for. There are many high-priority needs in the county: water, wastewater, emergency services, and lots of better ways we could serve the taxpayers. Entering into this contract for a matter that is clearly outside the scope of your authority is a slap in the face to your constituents and ignores your fiduciary responsibility to the taxpayers of Hood County.
Nate Criswell.
So we're here today to discuss if we're going to retain yet another law firm. As Ms. Samuelson stated, we already have a county attorney who is here to advise on such matters. Now, Mr. Massengill, I understand a lot of times you don't agree with him, so we also have Texas Association of Counties. Jim Allison down at TAC often weighs in on these issues, and his weighing in on this issue, this witch hunt, is that it should be filed in district court. Now, what is going on is we had Judge Massengill reach out to yet another law firm seeking the answer that he wanted. That's called Ma and Pa. Ma won't give it to you, so you ask Pa, or vice versa. That is not the proper way to do things. That is not fiscally responsible. And as Ms. Samuelson stated, this budget item is not some specific. We have had many discussions about budget items being some specific, and it's also not specific in its duration. So again, everyone knows why this is going on. I'm going to ask respectfully Commissioner Wilson and Commissioner Cotton to recuse themselves due to their endorsement of Mr. Eagle's opponent in the Republican primary. Thank you.
Pastor Mary Carton.
I am not a lawyer. I'm not as gifted as some of my friends here, even in government matters, but this is what I am. I am a people person. I'm a pastor. And I'm here because I believe this is wrong. This is very wrong. This is not right. I will vouch for Commissioner Eagle's character and integrity as I've experienced it. I've watched him come under attack since the get-go, and it was all political. I walk as a spiritual person with a gift of discernment, and this stinks to high heaven. I don't know how else to say it. I'm asking you to stop this. And the other thing I want to say is if you were at the school board meeting, the silent majority is coming alive, and we're watching, and we're not sleeping. And I think I could speak, I believe the majority of the Hood County Pastor Council is here. Maybe I could say with a majority, we're not sleeping anymore. We're up and alive, and we're asking you to do what's right. Thank you.
Amen.
Judge, Commissioners, I want to echo what Pastor Mary just said. We need to have you do the right thing in this particular case. One of the things that Mr. Kimbrough said, that as soon as he got the call, that his firm went in to check, as all law firms would do when they consider an engagement. They went in to check to see if there was any conflict that might come to bear in regards to this engagement. I would submit to you that there are people, some of the commissioners here, that are conflicted. And I would echo a previous speaker's request that if that's the case, that the two of you that endorsed Mr. Eagle's opponent during the primary election recuse themselves from voting on this issue, for sure. You're conflicted. So do the right thing in that regard. I would also echo a previous speaker's comment that we already have a county attorney that can render a decision, an opinion in this regard, in what you're considering. So use the available resources that we have, and let's do this right. The final thing that I would say is that if you decide as a commissioner's court to move forward with engaging this law firm, then by all means do it. Because I tell you what, if you engage this law firm, what you are doing is you are sending a signal that you will need that law firm time and time and time again. You all will need it. So stop this, please. Thank you.
Thank you. Mr. Kimbrough, so you came up and we got to hear the history of your law firm and that this field of practice is what you are specialized in as far as taking these kind of issues. And you acknowledge that this would not be a substantive investigation. And you acknowledge that the Commissioner's Court only has those powers that are expressly given and that they are a limited government body. As a learned firm in this area, and having heard, we've heard that the election code provides that this type of thing should be addressed in the district court, and even the person in support of this petition, who was the opponent on the ballot, acknowledges that the court, it also should be decided by a district court. As you sit here today as a learned firm, I'm wondering, how much time do you anticipate having to put in to make a decision on whether or not this court can address this petition? Because what I'm hearing from you is that on its face, it seems perfectly clear to me, to others here, and to this body that this is not the appropriate forum. So how much time is it going to take your learned firm to make a decision based on this petition? My name is Christine Leftwich.
Mr. Kimbrough, can you come up to the microphone, please?
We can share it.
Okay.
Ms. Leftwich, I haven't seen a document.
Okay.
I've had a short telephone conversation with the county judge. Can you hear me? All right, I'm sorry. When I walked in the door, I was introduced to the sheriff. I had no substantive conversation about this matter with him. I've been talking to some of my gallery mates over here from time to time. I've had no substantive conversation. I've seen no documents. I don't know how long it's going to take. I don't know how long the petition is. I really don't know what it says. But I have my doubts about the ability of them to do a criminal investigation.
Okay.
Okay?
Okay.
I want to not leave here without saying that.
Okay.
But to what level or degree, if they choose to place a matter, since the people signed a petition and gave it to the Commissioners Court. To what level or degree can the Commissioners Court agenda this item and discuss it? To what level or degree can the court or members of the court make referrals to higher-ups in government? I think that's something that needs to be addressed.
Well, and I guess what I'm asking is, given your experience in this field of practice and everything, what are you looking for a loophole that's going to allow this court to overreach its authority in the law? Because that's what we're hearing. We're hearing that there are already laws in place, and you're saying that the court only has those express powers this is a limited body of government. So as someone this has been your field of practice, surely you are intimately familiar with what the laws already are. I guess what I'm asking is, as we sit here today, I'm not understanding how you can't just say, I'm sorry, this is not something that your court can take up. This needs to be addressed by the district court.
I haven't seen the facts. And our professional responsibility, the ethical rules say I'm not supposed to give advice until I have a client, and I don't have a client yet. You with me?
So you're going to be looking at something before you've actually been hired as a client, and then they'll make a determination on whether to hire you. I'm trying to just understand the process, because it seems like it's a little bit out of line.
We're not supposed to give legal advice to people who are not our clients or to groups that are not our clients. They are not, the county is not our client at the present time.
Okay, and so even though your firm practices in this area, you're not in a position right now to say, I'm sorry, but this is not something we can address. This needs to be taken up with the district court.
Ethically, I cannot.
Okay.
But the statutes are clear on removal authority, Chapter 87 of the Local Government Code, quo warranto authority under Chapter 66 of the Civil Practice and Remedies Code, the Election Code, statutory causes of action to get on or move somebody off a ballot. And if we're just talking about the law, none of those remedies involve the Commissioner's Court.
Okay.
Now, that's not legal advice. That's just talking a little bit between friends about what the law is.
Okay. Thank you.
Okay?
All right. Thank you.
Is that helpful?
Yes, it is. Thank you. Okay.
Judge and Commissioners, it seems like the issue before this court meeting is whether to engage this law firm to advise the legalities of what the Commissioners Court can do. One of the previous speakers said we've heard from Attorney General Ken Paxton. I didn't hear from Attorney General Ken Paxton. I've heard someone's opinion. I didn't hear from Attorney Allison. I heard someone's secondhand opinion. It seems that if the court wants to be proper, to have advice to stay within their legal bounds. And I also heard Mr. Kimbrough say that it's the court that will contact them, and that would mean a majority opinion vote of the court, and not any individual can just call them at random. So it seems like this is what you do in legal issues, and I am not a lawyer, nor do I profess to have any great skills there.
Thank you. Okay. Mr. Eagle, do you wish to say anything else?
Absolutely do. First of all, I want to deal with the procedural side of this issue at this special called meeting, because our own rules of decorum state that we have our commissioner's agenda in by noon on Wednesday with accompanying documentation. Now, that did not happen in this case because Commissioner Cotton, who just got voted out of office, put it on the agenda bareback. The documentation, as testified to by the learned attorney from Austin was not provided to this court, or to the judge, I should say, who was out in the hall with him, by the way, before this started, sua sponte together, that I saw with my own eyes. That did not get to this judge until Thursday night after hours, and this additional backup documentation did not hit the commissioners to give us a chance to review this information until Friday afternoon. And it was first emailed as backup documents for agenda item number 8, miscellaneous number 6, Roman numeral 6, Roman numeral 8, item 6. Well, they figured out that, oh, wait a minute. We can't add that documentation to this agenda item because we've breaking our own rules. So what does Commissioner Cotton do by himself, on his own? He goes back and renotices this as a special call meeting. So we can't call it a duck right now, we're going to call it a chicken. And that gives us authority now to look at this item, which I object to in the first place, because this should be moved to another time, where we all have a chance to adequately review the contract and seek our own counsel if need be, to see what this contract is getting us into, as well as talk to, in my case, the people who voted for me. What do you think about this? Now, that's the procedural argument that tells us why this is absolutely out of order. But since we're here...
Can I answer that portion of it before you go to the next one?
No, you can't. I'm talking right now.
Well, you're going to...
If you don't mind, I've got the floor.
Go ahead and finish.
So, regarding this contract with this Austin firm for review right this minute, and you know where it's going. I've got 3 political enemies here that are going to vote to do it. If you think I'm going to agree to sign off on this order to allow this judge sitting right here, this big city Democrat demagogue, a political enemy of mine, who fully No, I'm not. No, I'm not. This is a political hit job.
He can't talk to you like that.
You can't talk to me like that. I'm not a Democrat. Do you have the order of merit from the Republican Party? You do not, sir. I do have it.
My opponent in this recent primary, everybody knows what I just said. My opponent in the recent primary, who had standing to challenge my residency, did not do it. He had standing when he filed a run, but he didn't do it. My opponent in the primary 4 years ago, who presented this bogus petition, he had standing to challenge my residency then, and he did not do it. My Democrat opponent right now has standing to challenge it, and if you so choose, sir, then go right ahead. But if you think that I'm going to agree to this illegal witch hunt today, perpetrated by who I've already named, then I have some oceanfront property in Arizona. This is a blank check for the judge, a blank check to use your money to go after his political enemies. This is right out of the Democrat playbook. On top of all that, he's trying to bring, no offense to you, a group of Boston lawyers up here to do his dirty work. I urge you all to look up this name on the record. His name was Roland Freisler. Sind hier viele deutsche Leute Nile-Themen? Die Hände? Apparently no Germans here.
Ich bin sprechen die Deutsch.
He was a Nazi judge who ran Hitler's deadly People's Court. You can see films of him screaming at defendants, dressing them down, calling them names. That was Hitler's People's Court. And it was just a pretext. It was just a show. It was just theater to make it look like the defendant was getting some kind of a fair shake. And some of you probably have seen the black and white film of him ranting and raving and raging to the defendants that he's getting ready to execute. Freisler Chrysler believed that trials should be swift, judgments should be final, and punishment carried out within 24 hours. Some defendants were punished within an hour and a half. How were they punished? Beheaded, hanged. The primary runoff is May the 24th. Early voting starts on May the 9th. For real Republicans, I hope you remember what's going on today. Remember that I'm being brought in here by 3 people who are my political enemies, one of them who endorsed my opponent immediately after he filed, one of them who just got voted out who endorsed my opponent, and the judge sitting there who endorsed my opponent. And let's remember this for the potential pretextual display for what they're trying to do today. This is what a totalitarian government looks like. Some of you may not think the other choice in May 24th is the right one. Whatever the case, please vote your conscience on May the 24th. And if you do, I submit that come January the 1st, 2023, this judge isn't going to be sitting here. Now do your worst. Thank you.
Is it David Ferris? Ferris.
Commissioner Eagle, just to make sure that it's straight, Judge Massengill called this meeting, a special called meeting of the court, and he did it in accordance with our rules, 72 hours. Yes, he came in and tried to put it on the Commissioner's Court, and I told him you can't do that. Don't put it on the Commissioner's Court, you're too late, period. That's all I told him. He turned around and said, well, they put it on a special called meeting. I said, you can do that and give 72 hours. So I just want to make sure it's straight that this is not Ron Cotton's special called meeting.
Thank you, Commissioner. I appreciate that. Still a duck, a duck and a chicken.
And it's in accordance with the rules. It's been on file for the 72 hours that are required. Thank you, Commissioner Eagle, for your very learned remarks here today and trying to get county government at a unified front here. So, Mr. Ferris, please proceed.
Okay. Thank you. We moved here to Granbury a year and a half ago, roughly. So, long time Texas, but we moved back from New Hampshire not long ago. Retired here and been looking to. We were looking for a place that was had the values we were looking for. My biggest concern is that it appears to me that this court had a means available to inquire about the legality of how you should handle this. It does not appear that they took the in-house opinion, and it appears to me that maybe they didn't like the opinion. Why go outside? I see no reason to go outside until you've got that opinion, or you've gone down the road to Paxton, the Attorney General. I see no reason. It also concerns me that the appearance of impropriety based on the support of the candidate and of the fiduciary responsibility that this court should have with the money, that for anybody out here, depending upon how this goes, I'd be willing to discuss 3 more petitions.
Thank you, Judge Court. This is a question for Mr. Kimbrough. I'd like to know the nature of any relationship that you have or your firm has or has ever had with Judge Ron Massengill in any capacity.
None?
Good, glad to hear that. My next thing, Court, is I'm very curious to hear, and I can't make him come up here, curious to hear Matt Mills to find out what exactly it is his job is in relation to this, and what is it that Mr. Kimbrough's firm could do that he cannot do and is not authorized and required to do under state law already. Thank you.
Mr. Mills is the county attorney, correct?
Correct.
My understanding of state law says this: by written request, the Commissioner's Court can request a written opinion of the county attorney on any matter involving state law. And he's obligated to give it under the statutes. Does that sound right? Okay. I can't quote it to you, but it's in there somewhere. That's the rule I grew up with, is serving as the criminal district attorney in my home county for 12 years. Questions? The people are right. Right about that point of law. It's my understanding that if the Commissioner's Court votes to ask the county attorney to give a written opinion, he's obligated under the statutes to do so. Questions?
Thank you, Mr. Kimbrough.
Yes, sir.
Anything else?
I got a question for our county attorney. I'm sorry, Matt. You're not getting out of this deal. I know. I just have one real simple question for you, sir.
Okay.
Has anyone sent you a written request to investigate or to look at the law on this particular issue?
No.
Thank you.
I mean, the only questions I've received really at all from anybody is a couple from the Hood County News, just procedural, how does this work, what's this all about, whatever. And then you and Kevin reached out, and I talked to both of you. But I mean, like, the petitioners, the rest of the court, I mean, nobody's, and I've learned I have enough to do. I don't want to interject myself. So, I mean, if y'all want to go fight, you just go fight. And I'm not going to get in this unless I'm summoned. So I'm staying out of this until y'all summon me. So that's what I'm doing.
Thank you.
Can we ask the county attorney, when he was a commissioner on the Commissioner's Court, was he involved with the removal of a commissioner for non-residency issues?
He's already spoken, but if you want to do it.
I mean, is it?
It's not related to the agenda.
Yeah, I know. I was in high school. No, I was a lot younger.
Barely.
But no, there was in 2001 there was in precinct 2 a removal of a commissioner. I don't know if I should opine much further, but that
Why
it
not?
did happen. What's that?
Why not?
Well, I'm going to piss certain people off, but I mean, I was, you know, it was a commissioner's court. It was a 3-2 commissioner's court, kind of like it is now.
Can you say why they removed him?
I was part of the 3. Well, I think the facts were there. I mean, he had bought a house in Somerville County and was pretty much living in Somerville County as best I knew. He still had a house in Pecan. And it was a different deal because the sheriff was kind of aligned with the county judge, and they physically removed him from commissioner's court with sheriff's deputies and swore in a new county attorney on the spot. And then he sued the county, and they paid him something like 35, 40 grand to settle the suit to go away, and he went away, and the new commissioner kept going. And that was basically what happened. I mean, there was no filing, there was no quo warranto suit, there was nothing in district court. I mean, you just physically removed a guy, pulled him out of the chair, and swore in a new commissioner.
And the Commissioners Court had the authority to do that?
No, I mean, if there's a vacancy for a commissioner, the county judge has the authority under the law to appoint a vacancy. So they deemed that there was a vacancy, they removed the man from his seat and swore in a new commissioner and proceeded with Commissioners Court that day. So, as you can imagine, that was a courtroom full of people and a lot of controversy back then.
What happened to all the ones that did that later? They all get voted off, didn't they?
Yeah, I mean, we had 5 members, it was weird, we had 5 members of Commissioners Court, all 5 of us lost, and the sheriff lost.
So they threw the entire Commissioners Court out.
All of us, which side we were on, we all got thrown out. I was one of the 5 who ended up getting defeated, yes. Bad memory, thank you.
Let me ask you something here. Since you've already discussed this situation with both Commissioner Andrews and with Commissioner Eagles, that's what they said.
Right.
So you have an idea. You've also read the petition that was submitted to the commissioners.
No.
Have you?
No, I have not. I've not.
You've never even seen it?
Never seen it.
All right. You know the gist of it, about people making the allegations that Mr. Eagle does not reside in Precinct 4?
I've seen that.
Okay. All right. Are you ready, willing, and able to go ahead and do what you need to do based upon what Mr. Commissioner Andrews said about what Jim Allison has said that he said, and that what Paxton has said he said? Are you ready to go ahead and conduct your investigation and file a petition or do whatever the law requires you to do in this particular instance?
I mean, if the court and petitioners and so on want me to investigate and do some work, I mean, I've never turned any of y'all down, I don't think. I mean, I've never had one of you ask me to do something and I say, no, thank you, right? I mean, so if y'all ask me to do something and investigate, I will, so.
Okay. And you have the time to do this, right? Yeah.
I'm trying to hire an assistant.
You're not going to do it next year or next month or something. You can do it, right?
I mean, I'll do.
We've got people in the precinct that are asking you to do it.
Well, they haven't.
What we have heard today, not only from the people in the audience, but from Mr. Kimbrough, you know, the proper channel is through the county attorney or the district attorney, period. That's where it needs, you know, that's where it needs to go. So,
right.
you know, at this point, it's on you.
Well, I mean, if you wanted to go under the Quo Warranto Civil Practice and Remedies Code, yes, that would come either to me or it says it could go through the AG, which they're usually
It's either on you or the district attorney.
They never gave us a question that we asked them 12 months ago.
That right? That is 11. Yeah, almost. Yeah, we've been waiting way too long. So, yeah, it's been bad. So, I mean, the petitioners have never come to me, and the court has never voted to make or ask me to do anything. So, until somebody does that, I'm just going to do my own work. You know, I mean, aside from all that, I mean, I got plenty of criminal work to do.
Well, the way that the law reads is that Commissioner Eagle or any other commissioner, before you file, have got to live in the precinct for the 6 months preceding the filing. Am I correct?
I believe that's right, yes.
Okay. So it'd be pretty simple to get like utility bills to see if that residence was occupied the preceding 6 months. Am I correct?
That would be one factor.
Jim Allison reports that several facts are important in this determination, including a claim of homestead exemption, voter registration, auto registration, utility accounts, U.S. mail reports, and other factors.
Yeah.
So that's what it takes, right? But we're not the jury. That's not what we're trying to do. We're not trying to do that here. We're trying to determine who does that.
Yeah, I mean, I've seen 2 avenues. I mean, there was a filing with the mayor's race last summer, which I want to say was filed in the wrong court, and that's why it didn't get heard. I don't know, but when I looked at the filing, and this was the Charles Nangle filing against Jim Jarrett, they hired a Frisco law firm to do it. So, I mean, I would think Mr. Wood could hire a law firm, file the suit in the proper court, and that would be one way to do it, right? And then another way to do it, I guess, would be we could, either my office could do it, or we could get like a, Johnson County or some neighboring county who's not politically aligned or motivated, right?
Well, that's what the petition asked for.
Which, I mean, that's fine with me, too.
Well, one thing that would clear it up, if Mr. Eagle, since he lives there, or claims he lives there, he could get the utility bills for his residents for the preceding 6 months and probably come close to clearing all of this up, couldn't he?
That would be one factor.
When he came to see you, did he offer to bring the 6 months utility bills prior to his filing?
No, I didn't get into the facts of any of that. We were talking procedural stuff.
That was pretty well cleared up. If there's no electricity or no water commensurate with the family living there prior to 6 months of him filing, that would indicate that no one's living there. No one's living there. Whether he's living there or not, nobody would be living there. Am I right?
That would be a good indication.
How long would it take for you to subpoena, or I guess you'd have to have a case before you could subpoena records? Am I right?
This is not my usual line of work, but I mean, I'd have to do a lot of research, but.
Given what the, TAC has said, Jim Allison has said, he's made it real clear that the responsibility is in the county attorney or district attorney for the county. That's what's been stated.
Right. Yeah. It says, actually, this is weird, but I think an individual can file the suit, but it would have to be our office to move forward on it.
Correct.
Yeah, so.
I don't want to be a fly in the judge's ointment here, but having you do this is not on the agenda. We're talking about hiring another law firm. Be kind of nice to keep it on the agenda. If they want to take this up with you in the next meeting, that's fine. That's their prerogative. But I'm
that called you up here, Mr. Mills, wasn't it?
So we're going to, I think I rest my case about the political BS going on up here. I rest my case.
All right. Do y'all need anything more?
Talk to you later.
Okay, yeah, I guess so.
Thank you very much, Mr. Mills. Okay, you want to make a motion? Mr. Wilson?
I move based on the discussions that have been held and from the audience and from Mr. Kimbrough and Mr. Mills, at this point, that we take no action on this today, and we will make it appropriate, comments and agenda item for the next court to involve the county attorney.
Second. I'll second it.
I second it. So motion been made by Commissioner Wilson to table the motion about hiring the Biggerstaff law firm to give us the legal lay of the land based upon the statements made by both sides to this issue, and most importantly, the representations made by Matt Mills and his office here. And that was seconded by Judge Massengill. Any further discussion? All those in favor say aye.
Aye.
All opposed?
Wait a minute. Do you mind if I haven't cast my vote? I'm abstaining from this particular vote because I don't feel like I should vote on it since they're directing all this to me. So I abstain.
All right, but then it carries 4-1 abstention. Okay. There you go. Ladies and gentlemen, it's high noon. Thank you very much.